Welcome, and thank you for joining us for BakerHostetler's Class Action Defense 2024 Year in Review webinar. I am Julie Brady, co-leader of BakerHostetler's Class Action Defense team. It is my pleasure to introduce my partners and today's speakers. Joining me today is my co-leader of the Class Action Defense team, Bethany Lukitsch, as well as Michelle Gomez from the Privacy and Digital Risk Class Action Litigation Group based in our Denver office, Dante Marinucci from our Class Action Defense team out of our Cleveland office, and Kevin Zimmerman from the Insurance Class Action team out of our Columbus office. Today, we'll be discussing significant cases and developments in the class action space over the course of 2024, and we'll offer our predictions as we head into 2025. This is a 1 hour and 15-minute presentation. We will do our best to answer your questions during the presentation, which you may enter through the chat function. For questions that we are not able to answer during the program, please feel free to contact us. Next slide. This program will touch on the following areas: false advertising and labeling class actions presented by Bethany, privacy and data risk class actions presented by Michelle, insurance class actions presented by Kevin, and financial services class actions presented by Dante. And I will close out the program with an update as to key appellate decisions. A few house notes first. This program is appropriate for both newly admitted attorneys and experienced attorneys. CLE is approved for California, Florida, Georgia, Illinois, Kansas, Michigan, Nevada, New Jersey, North Carolina, New York, Ohio, Pennsylvania, Texas, Virginia, and Washington, and credit is available from other states upon request. Slide 4. During the program, we will share 2 CLE codes, which you will need to write down and enter in the post-webinar survey in order to receive CLE credit. You should see the first code now. The word is dragon, as we are closing out the year of the dragon. The post-webinar survey will begin immediately following this presentation, so there's nothing you need to do to start the survey. If for any reason you have trouble, please email ClassActionEvents@bakerlaw.com for a PDF of the survey. This email information will be provided at the end of the program as well. And now I will turn it over to Bethany to discuss false advertising and labeling class actions. Bethany?
Find my unmute button. So welcome. We're going to start the program off today with an overview of some of the key trends in the false advertising and labeling class action space. Next slide. So there are a lot of different types of false advertising cases and labeling cases filed. The majority of these cases are pending in California, New York, and Illinois, although a handful of these cases will be filed across the United States, as you'll see throughout the presentation. I'm going to cover 5 basic topics. The first, no preservative or preservative-free claims. Second, a more general discussion of greenwashing claims, claims about sustainability, clean, safe. Next, a third trend is plant-based claims. The fourth trend is pricing class actions. And the 5th trend is auto renewal class actions. And then I'll close out my section by making some predictions of 2025. Next slide. So the first trend deals with no preservative or preservative-free claims. We saw approximately 24 of these cases be filed in 2024. The cases include a variety of different products, predominantly food products such as popcorn, canned pasta, fruit snacks, fruit punch, energy drinks, but also a handful of other products, cat treats, shampoo, and lip balm. Plaintiffs continue to test these no preservative claims almost mainly in New York, Illinois, and California under the various different consumer protection statutes and various different common law claims. Most of these cases have been voluntarily dismissed. We suspect that in many of those cases, there's some sort of individual settlement that has been reached, although not necessarily disclosed. The primary target of these cases has been citric acid. There are also cases involving other types of ingredients, such as vitamin C and malic acid, to name a few others. The debate in these cases is really, does the ingredient, which most often is disclosed in the ingredient list on the label, is it functioning as a preservative in the product, or does it have some other function? And many of these cases are surviving a motion to dismiss, depending on how they are pled, based on the fact that the court determines that these issues are factual in nature and cannot be decided at the pleading stage. Next slide. The next trend is clean, safe, and sustainable claims. I have a handful of example cases that are on this slide. A couple of them we've spoken about before, the Schwartz case. And I wanted to bring your attention to a troubling class certification opinion, or troubling opinion that came out of the Southern District this fall in the Nestle Falcone case. This case deals with claims of sustainability on 8 different products. In this case, the court did grant class certification of both an injunctive relief class and a refund class. The causes of action that were at issue still at the class certification stage are UCL, unfair competition law, and the CLRA. There were a couple of different findings of the court that I want to bring to your attention. One, the court found that variation in messaging did not destroy commonality. Here, the products all had a different combination of sustainability claims on their packaging. And there the court said that the defendant's documents that the plaintiff had pointed out showed that the defendant viewed in some cases that these sustainability claims were interchangeable. The court also found that the UCL did not require any sort of individual inquiry of any sort of misleading nature of the claims, that it could be tested by the reasonable consumer. The court found that the sustainability claims need not be the sole or even predominant factor in the purchase of the product, just a substantial factor. And finally, the court found that actual injury, for purposes of the CLRA, could be handled on a materiality basis based on an objective standard. And the court found that plaintiff did not need to prove materiality at the class certification stage, just needed to come up with a common methodology. So that case is currently on appeal to the Ninth Circuit over the class cert decision, and we will be following up, I'm sure, in our next session. Next slide. A third trend that we are seeing in false advertising cases that have been filed in 2024 are cases dealing with the claim of plant-based. Plaintiffs' counsel argue that plant-based means something that the product is, for example, more environmentally friendly, that it's safer, that it is more natural. And here you can see a variety of products that are targeted by these plant-based claims and litigation. Wipes are a common product that has been targeted. We also see food products that are targeted, feminine care products, and things such as diapers. And I want to remind you of a case that Julie covered in our earlier session this year, dealing with reasonable consumer and what a reasonable consumer believes or understands, and that's the Whiteside case. And in that case, plant-based on some of the different Huggies products were followed by an asterisk. Some products had the asterisk, some products did not. The lower court dismissed all of the claims, finding that the qualifying statements on the back labels made these products and these claims not confusing and not misleading. The Ninth Circuit, however, reversed and found they did uphold those decisions and the dismissals with products that had the asterisks next to the plant-based. And there it found that the court properly examined the back label of the product to understand this potentially ambiguous claim. But the court did reverse on the unasterisked products and found that the front label could be read as being unambiguous, and therefore the court incorrectly reviewed the back label in conjunction with that analysis. This case was remanded to the district court and ultimately likely was resolved at individual settlement, and it has been dismissed. Next slide. Our fourth trend that we want to cover is pricing cases. There has been a slew of false discount or reference pricing or sale pricing class actions that have been popping up predominantly in California. And these show no signs of slowing down. They are being filed by an increasing number of plaintiffs' firms. Some of those firms include Lynch Carpenter, Pacific Trial Attorneys, Double and Lunar, Milberg, Siri and Glimstead. I have a couple of different exemplar class actions that are currently pending in federal court. Some in New York, some in California, some in Oregon. Almost all of those cases, even if not filed in California, deal with California's laws. There are 19 states, and the FTC also has guidance on when you can use comparative pricing and when you can use certain particular words like sale or include a strike-through price or a reference price. But California is one of the most strict states, along with some of the other states on the West Coast, and also very active borrowing statutes. So these statutes in and of themselves are being harnessed with other kinds of statutes like CLRA, UCL, and FAO. And you see a bunch of different settlements that are listed there, and the types of different relief that is being provided to customers. Most of these are on a claims-made basis. Next slide. And our final trend that I'm going to cover in the false advertising space deals with subscription and auto renewal cases. So you can see a couple of recent class actions that are filed, a bunch of different settlements, some on an individual basis, some on a class-wide basis, predominantly to California classes. And then I have two specific mentions there. One is the FTC's new final rule that was published, came out in October of 2024. It was published in November, and it goes into effect 180 days from publication, so approximately in May. And California has also updated its auto renewal law with some additional requirements of express consent, also expanding it to cover free subscriptions that turn into paid subscriptions, and including some other notices to consumers. California and the FTC rules do not have specific private right of action. California, again, plaintiffs are using the sort of common three statutes as well as common law theories to pursue these auto renewal cases. But we again saw an uptick in these cases in 2024. Next slide. And now predictions for 2025. So I again expect that California, Illinois, and New York will continue to be the focal point for false advertising and consumer class actions. I expect that greenwashing, no preservative, clean, and natural claims will continue to be brought at a steady pace through the courts. We have an increased scrutiny on chemicals like PFAS and other different chemicals and substances in our products and food. And so I expect those to continue to be tested. I also expect that pricing and junk fee class actions are not going to go away. There are a ton of these cases being filed. I think some of these cases are going to lead to some interesting decisions on motions to dismiss and potentially beyond. And so I think those cases are going to continue in 2025. I also think we need to be on alert if you run some sort of subscription or auto renewal process to pay attention to those. The state laws are varying. California and the FTC have new rules that go into effect in 2025. And typically when we see those changes take place, we also see changes by the plaintiff's bar in the class action space. And then finally, I leave sort of this open question is what will be the impact of the new administration? We see that the new administration is already focused on marketing to children. And we also see a focus on healthy foods and healthy products. And so I think that the plaintiff's bar will be watching closely, and we may potentially see more actions in that space. And so with that, I'm going to go ahead and pass the baton to Michelle Gomez, who is going to bring you up to speed on privacy and digital risk class actions.
Thank you so much, Bethany, for that great introduction, that overview. Next slide, please. So 2024, we had a lot of action in the data privacy space. Some of the trends here are first, some certification whiplash, some notable cases that we want to cover during the first slide, and standing issues. Standing continues to be important for any class that's going to move through litigation, really assessing whether your plaintiff should be in court at all at this juncture. The second trend that we saw is healthcare web tracking lawsuits. There was quite a surge at the end of 2023 and even into 2024, and some updates on what the settlement landscape looks like for tracking technology and how do you even build a class around tracking technology concepts. The third trend is the California privacy class actions. They just keep coming. Number 4, BIPA class actions. They are still around. They are still being filed, but we have some good news for healthcare entities over the last year. The fifth trend is VPPA class actions, video privacy. They are slowing down a little bit, but they're not dead. And those continue to get filed, but they are not as prolific as some of the other cases that we are seeing. And last, the rise of AI, what that means, new tools that are coming, and also potential risks that organizations should be thinking about. Not only IT, but make sure your legal department is consulted when you are considering rolling out new tools for customers, patients, things like that. So next slide, please. Trend number 1 is on data breach class action specifically, and I jokingly titled this, "If at first you don't succeed." We saw some whiplash on some of these cases, reversing certification orders, really clarifying some issues in terms of ascertainability, predominance. So these are some important cases. If you are dealing with data breach class actions specifically, these 4 cases are some that you may want to look at and reference if you are defending a class action data breach. and are trying to figure out, what's the lay of the land as of 2023 and 2024. Next slide, please. Something else that we saw, which was interesting, is courts sua sponte assessing standing issues, even when the parties had not briefed that to the court. We saw that in the Middle District of Florida most recently. The court denied preliminary approval of a settlement and sua sponte remanded the case on the judge's own initiative, finding issues with even allegations of fraudulent credit card charges, because the plaintiff failed to plead facts plausibly alleging that those injuries were fairly traceable to the data incident. The judge even went farther and said even if there was standing, there's going to be predominance problems under 23b3 that would make it difficult to certify the class. So we saw that after that opinion came out, a dozen or so related cases had sua sponte show cause orders for standing. So it is really important at the beginning for defense counsel, for defendants to assess who you're dealing with on the other side, really looking at those allegations. Are they actually a patient or customer of your organization? And do their allegations of injury really line up with the facts of how the incident occurred, when it occurred, or some of the data points that were at issue in the incident but may not line up neatly with your plaintiff? Next slide, please. Trend number 2 is one that I certainly saw a lot of in my practice. This is healthcare specific web tracking litigation. We have had many clients who have been sued in jurisdictions all across the country, almost everyone, relating to Metapixel, Google Analytics, other types of tracking technologies that are being used on websites without first obtaining consent from website visitors. There's a lot of litigation now post-Becerra about whether, what about unauthenticated portions of the website as opposed to your authenticated login portions. We represent a number of healthcare organizations. I think it's over 100 at this point, but it is hot and heavy. And we definitely saw a surge in 2024 of these types of cases. Next slide, please. Some case developments that have come out of these pixel or tracking technology litigations at the pleading stage, they have stickiness. They're very difficult to win on an outright dismissal, or if we've obtained a dismissal, there's usually leave to amend. And usually what we're seeing is plaintiff's counsel really plays up the ick factor, right? We trust our hospitals to keep our information confidential, and they are revealing our IP address, or they are revealing our search bar results, or whatever it is. And that makes a lot of judges uncomfortable, at least at the initial pleading stage, of dismissing those cases outright. Some key issues on appeal that we noticed, we have had a number of cases where state courts are not always friendly forums for a defendant. So, trying to remove those cases based on the federal officer statute certainly had some success in the beginning. We had a couple of courts which signed on to that argument, and then the vast majority reversed and said, no, you can't use the federal officer statute to get you in federal court. The appellate courts, which have officially said no to that procedure, are the 3rd, 5th, 8th, and 9th. And we are waiting on decisions from the 7th and 10th Circuit, but we are not holding our breath over those. Another, interesting development was the Massachusetts wiretap statute, which did not cover tracking technology that was alleged in that case. That was a big decision that recently came out. We've also got some class certification orders, a denial in MedStar, and a certification granted in Virginia Mason. So these cases are still ones to watch. They're not fully baked and developed. So we will get additional guidance as the new year 2025 comes. But for now, these are some of the important developments. Next slide, please. Just quickly as an overview for those who aren't familiar with tracking litigation, we see the kitchen sink of claims, square peg, round hole, right? Anything that plaintiffs can latch onto, old statutes, old concepts of law are being applied to new technologies in ways that were not envisioned in the past. The relief is very broad. Actual damages, statutory damages, they really plead everything in these complaints. And one thing that we're starting to grapple with is class definitions, how they are defined. Is it any visitor to the website? Is it just patients? What about patients who don't use the website? What about portal users? What if the tracking technologies aren't in the portal? And which years are we talking about? And what statutes of limitation apply? These are questions that we continue to wrestle with in some of these tracking technology cases that make it past the pleading stage. We're also starting to see a settlement landscape starting to develop. We're starting to see something between $4 and $7 per person in most cases. Of course, there are certainly outliers. There's certainly facts and jurisdictions that drive those numbers higher or lower. But again, we are still seeing, the landscape starting to firm up and starting to get an idea of how do we value these cases? How do we, get our arms around the class and things like that? Next slide, please. Trend number 3 is for our California friends. SIPA is alive and well. These cases continue to flood California courts and arbitrations. They come in a variety of what we call flavors. Original chat cases, again, pixel cases, which I just mentioned, trap and trace pen register cases, search bar if you're searching for information. Is the website capturing that and transmitting that? And it's tough to say what the trends are because the outcomes are really judge, court, and case dependent. Although we do have a few recent wins to note underneath this slide. Next slide, please. Trend number 4, BIPA still hangs on, not as much for healthcare. So bottom line, who's getting sued for BIPA? Everyone who uses or contracts with vendors to use biometric data. I won't cover the statutory interpretation of what it is, what it requires, but it is important, and it comes with some pretty large statutory penalties or liquidated damages for reckless and intentional violations. Some good news is that the Illinois Supreme Court held that BIPA does not apply to information collected, used, or stored for healthcare treatment, payment, or operations. So that is some good news for the healthcare sector. Next slide, please. VPPA litigation, it is still ongoing. It is slowing down. Some of the early cases did not have much success, but there are some recent notable wins, which have shifted the tide a little bit in those cases. And next slide will show you why. We're really focusing in those cases on some of these key defenses that courts are really, getting some traction with and really paying attention to. Not it, right? Or no PII is disclosed, or the disclosure is not knowing, or the person's not a consumer, or you have consent, things like that. Of course, the pendulum always swings. When it swings one way, swings the other. And so one trend that we are seeing is that more plaintiffs' firms are threatening mass arbitrations or using the threat of huge arbitration costs to push for settlements in some of these VPPA cases. Next slide, please. The last trend that I want to talk about is AI, artificial intelligence, which is very exciting. So many new things coming out. And really, if your organization is using AI or considering using AI, artificial intelligence, it's really important to consider why you're using it and what you're using it for. Here are just some general categories of, are you using it for monitoring? Are you using it to try to predict trends? Are you using it to make decisions, employment, or advertising? Are you generating images with AI? It is an incredibly exciting time for technology, but typically technology outpaces law and regulation, and those things catch up to where technology is. So it's truly important to really assess how your organization might use these tools, and then talk to your compliance, talk to your lawyers, or talk to BakerHostetler about some of those risks. Next slide, please. And just some quick overview of foreseeable litigation risks from an AI perspective is, of course, security vulnerabilities, privacy risks as well. And then there's other risks. Certainly copyright litigation is very, very popular right now, a surge in 2024 following the rollout of some of these products. So with that, I'm going to go to the last slide, which is the trends that we predict for 2025. In my group particularly, I am seeing way more class actions for smaller and smaller breaches, 500 people, 1,000, 1,500. I am seeing settlement structures move in different directions. Data breach, unfortunately, those are tending towards common fund. Tracking technology cases began in the common fund space, but are starting to track towards hybrid models and claims made models, which is very interesting. Settlements incorporating new products and tools that weren't even in existence 2 years ago, but credit monitoring was in fashion at one point. Well, now we have different financial shield and privacy products that are really tailored to some of these claims. We're seeing more forum shopping mid-case or to obtain preliminary approval, even moving cases away from federal court. And again, I also predict this is the dawn of AI litigation. So with that, I will turn this over to Kevin Zimmerman to give the next update.
Thanks very much, Michelle. I appreciate it. Next slide, please, Cassie. So I'll be discussing some of the following trends from insurance class actions in 2024, which hopefully also provide sort of more general lessons about class action practice across industries. First, individualized inquiries as to which class members were injured by allegedly unlawful conduct continue to defeat predominance in insurance class actions. Second, cases have further recognized that this issue, this individualized injury issue, may be implicated by the injury in fact requirement for Article 3 standing too. Third, Article 3 standing continues to grow as an individualized defense on the merits in insurance class actions. Fourth, a recent opinion from the Ninth Circuit, Moe v. Geico, has led district courts to independently challenge jurisdiction under the Class Action Fairness Act, even when not challenged by the opposing party, by plaintiff. And finally, fifth, total loss, tax, and fee insurance cases continue to split the courts on the merits. Next slide, please. So multiple insurance cases this year have recognized that allegedly common unlawful conduct is not always sufficient to satisfy predominance. Instead, particularly in the insurance industry, where the ultimate contractual obligation is indemnification, payment for loss, individualized issues as to who is actually harmed by the allegedly unlawful conduct have continued to defeat class certification. Next slide. Our first example of this comes from the life insurance space, Small v. Allianz Life from the Ninth Circuit. There was a new California statute that required life insurers to notify their insureds of the right to designate third parties to receive notice of impending terminations or missed premiums. Essentially, this notice could allow the interested third party to address the impending termination to ensure that the premiums were paid or that the policy wasn't canceled if they had an interest in the policy. There was some litigation in the California state courts about when the notice obligation took effect, but in this case, the small case, it was undisputed that the insurer here did not provide the notices by the date required by California law. Next slide. However, the Ninth Circuit held that this undisputed unlawful conduct did not necessarily satisfy predominance. Plaintiff's cause of action here was for breach of contract, so it wasn't sufficient to just establish a statutory violation. Plaintiff had to show that the alleged violation of the contract or the statute actually harmed the insureds in some way. But plaintiffs couldn't do that because some people who had their policies canceled actually wanted that. There was no way to determine which insureds had their policies canceled because they didn't receive the notice, as opposed to some other cause. For example, voluntarily cancellation because the policy was too expensive, old age, policy no longer wanted, etc. These individualized inquiries as to who was actually injured by the notice or the failure to send the notice defeated predominance. Next slide, please. Another case exemplifying this issue is Jama v. State Farm out of the Ninth Circuit. This is one of a number of cases across the country challenging the methods that insurers use to determine the pre-accident value of a totaled automobile. Plaintiffs have challenged various aspects of these valuations in cases across the country. Next slide, please. Here, plaintiffs challenge both a negotiation adjustment and a condition adjustment, and the court certified a class based on one, but not the other. Starting with the negotiation adjustment, the court did certify a class of insureds subject to this adjustment. The valuation used by the insurer were based on the list price of comparable vehicles for sale in the local market. Essentially, the price dealers listed the vehicle for sale at the dealership. The negotiation adjustment, which resulted in a certified class, accounted for the difference between the list price or the advertised price of used vehicles versus what consumers actually ended up paying after negotiating with their dealers. Plaintiff's theory for this adjustment was that it was entirely unlawful, so anyone who was subject to the adjustment was necessarily harmed. The court agreed that this was a common theory of liability and thus certified a class. However, plaintiff could not prove the same thing for the condition adjustment. For this part of the valuation, it was undisputed that an insurer should account for the unique condition of the vehicle to determine its value. So, in other words, a condition adjustment was not per se unlawful. And because of that, an individualized inquiry would be required to determine who was actually harmed by the condition adjustment. That individualized inquiry defeated predominance as to that adjustment. Next slide, please. So that brings us to topic 2. The lessons from the cases we just discussed is that if individualized inquiries are required to determine who is actually harmed by allegedly unlawful conduct, that can defeat predominance. The cases I just discussed focused on harm or injury as an element of the underlying cause of action, for example, for breach of contract. But every claim in federal court requires an injury in fact for Article 3 standing. So that raises the question, can that defeat predominance too? Next slide, please. The Sixth Circuit is poised to address this issue soon. Clippinger v. State Farm is another total loss class action challenging a negotiation adjustment like what was at issue in JAMA. The district court here from the Western District of Tennessee relied on Sixth Circuit precedent decided before the Supreme Court's Article 3 standing opinion in TransUnion and held that a class could be certified based on a common legal injury, even if that legal injury did not result in underpayment for every class member in the class. Next slide. The Sixth Circuit accepted a Rule 23F appeal of the certification decision, and a key issue on appeal is whether the court could certify a class based on a common legal injury, even if that didn't result in an actual Article 3 injury in fact for every class member. Even other district courts in the Sixth Circuit have recognized that if the court addresses this issue, it could be an important class circuit precedent moving forward. Right now, the Clippinger appeal is fully briefed, but oral argument isn't yet scheduled. We'd expect oral argument sometime in 2025 and possibly a decision in 2025 as well. It's certainly one we'll be keeping an eye on. Next slide, please. On the merits side of Article 3 standing, recent insurance class actions also show the power of standing as a merits defense. These opinions are important on their own for the merits of the case, but also for class certification. The more difficult it is to show an injury in fact for Article 3 standing, the more often Article 3 issues may give rise to predominance arguments too. Next slide. The first example of this is Lewis v. Geico from the Third Circuit. This was another total loss valuation case where the plaintiff challenged a condition adjustment for a total loss vehicle. But in this particular case, the insurer actually applied a separate upward so-called adjustment to settle, which effectively was a compromise payment to resolve the claim. The court looked at that payment and said, well, look, you were paid more under the positive adjustment than the alleged negative impact of the condition adjustment, so plaintiff, you individually didn't suffer any real-world financial injury. That means you don't have standing. The plaintiff attempted to argue that the insurer might have paid even more if the negative adjustment wasn't applied, but the court said that that was too speculative to confer standing and thus dismissed this claim as to the named plaintiff. Next slide. The next standing case comes from the Fourth Circuit. Here, the Centers for Medicaid and Medicaid Services, CMS, had sent a collection letter to the plaintiff asking her to reimburse CMS for certain treatment her deceased husband had received. The plaintiff alleged that it was her insurer's obligation to reimburse CMS, and she brought putative class claims on that issue. But according to the Fourth Circuit, the collection letter that the plaintiff received was not sufficient to confer standing. Plaintiff hadn't yet paid anything to CMS, so there was no existing monetary injury. The court explained that the risk of future monetary loss can establish injury in fact for injunctive relief, but it can't by itself establish a concrete injury necessary to seek damages. Again, the court dismissed for lack of standing. Next slide. Our fourth trend is that Moe v. Geico has taken hold in the Ninth Circuit. It's not a trend specific to the insurance industry, but I wanted to mention it because it stems from an insurance class action that the Ninth Circuit decided last year, Moe v. Geico. Moe v. Geico discussed the allegations or evidence necessary to remove a case to federal court under the Class Action Fairness Act. In Dart v. Cherokee, a few years prior, the United States Supreme Court held that CAFA removal, Class Action Fairness Act removal, only required allegations in support of jurisdiction. Actual evidence in the form of data, declarations, etc., was only required if jurisdiction was actually challenged. Since Dart, that typically meant that evidence was only required if jurisdiction was challenged by the plaintiff after removal. But in Moe v. Geico, the Ninth Circuit held that it had an independent obligation to satisfy itself of jurisdiction, even though neither the district court nor the plaintiff had challenged jurisdiction below. So on appeal, the Ninth Circuit independently challenged the defendant's allegations of jurisdiction and remanded to the district court to assess actual evidence in support of that. Next slide, please. After Moe, some district courts in the Ninth Circuit have taken it upon themselves to challenge a defendant's support for CAFA removal, issuing orders to show cause, independently questioning jurisdiction, even if the plaintiff hadn't. We still don't see this very much outside of the Ninth, but it's something to be aware of if you're trying to remove a case in the Ninth Circuit. Next slide, please. Finally, our last trend from 2025 is that total loss tax and fee theories just continue to divide the courts. These cases do not involve the valuation of total loss vehicles, but instead whether insurers are required to pay additional taxes and fees allegedly necessary to purchase a replacement vehicle. The trend here is simply that the tax and fee cases continue to split the courts. Kind of like the labor depreciation class actions from the last several years, the results here often just come down to the unique aspects of each state's common law and total loss regulation. Next slide. So to conclude, our predictions for 2025 are as follows. First, we'll continue to see a focus on individualized issues of injury in insurance class actions. In the insurance context, this will often mean individualized issues as to who is actually underpaid by the allegedly unlawful conduct. Second, we expect to see further attempts to utilize Article 3 standing as the predicate for these arguments, particularly depending on how Clippinger v. State Farm is resolved. Third, we expect to see new theories emerge relating to total loss class actions. The total loss valuation cases like JAMA and Lewis v. Geico have mostly played themselves through the federal courts at this point. With clearer contours about those cases already established, we're starting to see new theories popping up relating to total loss insurance claims. Fourth, on CAFA jurisdiction, we don't really expect to see Moe v. Geico approach take hold in other jurisdictions outside of the Ninth. But if you're in the Ninth Circuit, it's something to keep an eye on. You'll want to consider sort of beefing up your jurisdictional allegations or evidence at the time of removal to hopefully shortcut any challenge from the court. And finally, because of the continued split in precedent, we may see a revival of tax and fee cases in new jurisdictions in the new year. We've already seen some new cases pop up in the second half of 2024 just because of the unsettled nature of this law. With that, I'll pass it on to Dante to give an update on financial services class actions.
Thanks, Kevin, and hi, everyone. Thank you all for being here with us. I'm going to talk about 5 highlights for financial services class actions from 2024. First, in Cantero versus Bank of America, the Supreme Court clarified the analysis that courts need to conduct when determining whether federal law preempts state laws for national banks. Second, in Loper Bright Enterprises versus Raimondo, the Supreme Court overturned the 40-year-old principles established in Chevron, which require deference to regulators' interpretation of laws. Next, I'm really going to combine 3 and 4 here. We've continued to see financial institutions successfully raise Article 3 standing defenses stemming from the Supreme Court's 2021 decision in TransUnion. Some other folks today have talked about that. We've also very recently seen some courts reject those challenges, including in instances when certifying a class in a data privacy case. Finally, the Fourth Circuit recently reaffirmed the ascertainability requirement of Rule 23 in a TCPA's called Career Counseling versus AmeriFactors Financial. Plaintiffs have filed a petition for writ with the Supreme Court that's currently pending, and that'll be an interesting one to watch to see if the court takes that case up. Next slide, please, Cass. Thank you. So in Cantero, the Supreme Court unanimously clarified the standard that that courts should apply to determine when federal laws preempt state laws that purport to regulate national banks. So as some folks may know, we have a dual system of banking. Banks can choose whether to obtain their charters from the federal government or the state government. And the type of charter they obtain determines which regulations they're subject to, federal or state laws. So Cantero involved a New York state law that required mortgage lenders to pay interest to borrowers on escrow accounts. But Bank of America has a federal charter, and at the federal level, the Real Estate Settlement Procedures Act set out the general terms for national banks that operate escrow accounts. That law does not require mortgage lenders to pay interest. Bank of America did not pay interest to borrowers for their escrow accounts. The plaintiff sued, and the district court found that Bank of America was in fact subject to New York law. The Second Circuit then reversed, finding that the National Bank Act preempted New York's law. And ultimately, this year, the Supreme Court vacated and remanded that decision, finding that the Second Circuit failed to apply the appropriate standard in evaluating preemption. And more specifically, the court really reiterated that Dodd-Frank established that the National Bank Act preempts state laws only if the state law discriminates against national banks as compared to state banks, or more importantly for this case in the discussion today, if the law prevents or significantly interferes with the exercise by the national bank of its powers as determined in accordance with the legal standard for preemption that the Supreme Court laid out in the 1996 case, Barnett Bank. So at a more practical level, the court directed lower courts to really do two things when analyzing preemption. The first is to look to analogous preemption decisions. And that sounds obvious, but the court went through a pretty detailed analysis of what it had previously done in the Barnett Bank case and discussed that in detail and ordered that lower courts need to do that type of analysis of looking to see how other preemption decisions have come out. The court also said that when trying to apply the standard, they need to make a practical assessment of the nature and degree of the interference caused by state law. If the state law prevents or significantly interferes with the national bank's exercise of its powers, it's preempted. If it doesn't, then the law is not preempted. So we've already seen this case. We go to the next slide, please. Cassie. Thank you. So what are the implications here? We've already seen a couple cases that have applied this, but I think at a high level, when analyzing preemption, courts are going to have to complete a nuanced comparative analysis of preemption precedent and then make a practical assessment. So I think cases are probably going to be more complicated that involve preemption than maybe they were in the past. In the couple cases that have evaluated this, the first is actually the second case listed, which is a class case in Ray Capital One 360 saving account interest rate litigation in the Eastern District of Virginia. Their plaintiffs brought multi-district, it's a multi-district case, and plaintiffs brought class actions asserting 23 claims relating to savings account holders. They alleged that Capital One failed to provide them higher interest that was available to other account holders by creating duplicate accounts. Capital One argued that the National Bank Act preempted some of the plaintiff's state claims, and the court conducted a detailed Cantero analysis and ultimately found that the federal laws did not preempt any of those state claims. In the first case I have listed here from the Northern District of Illinois, the court came to a different conclusion. There, the plaintiff was Illinois Bankers Association, which is a trade association representing financial institutions. The plaintiff moved for a pre-enforcement injunctive order, giving it relief from the Illinois Interchange Free Prohibition Act, which was to take effect in July of this year. That law prohibited financial institutions from charging credit and debit card interchange fees on the tax and tip portion of transactions. The plaintiff, on behalf of financial institutions, alleged that federal laws preempted that state statute. And again, that the Northern District of Illinois conducted a detailed Cantero analysis and found that the plaintiff did make a sufficient showing that the National Bank Act likely preempted Illinois law. So as we move forward in 2025, I would expect that we're going to see more applications of Cantero to determine whether plaintiffs' actions under regulations are preempted or not. Next slide, please, Cassie. So the second topic that I want to talk about is what happened in Loper Bright Eyes Enterprise versus Raimondo. And there, it's a pretty famous decision at this point. The court overruled Chevron, which had for 40 years governed the framework for courts' interpretation of statutes that federal agencies administer. So Chevron required that in instances where a statute was silent or ambiguous, courts needed to defer to a regulatory agency's interpretation as long as it was based on a permissible construction of the statute. And so we often refer to that as Chevron deference. In Loper, the court overruled that doctrine and said going forward, courts need to exercise their independent judgment in deciding whether the agency has acted within its statutory authority. So that is obviously a wholesale change. And Cassie, if you go to the next slide, we've started to see cases interpreting statutory analysis through this new lens of Loper. It's going to end up affecting financial services class actions for a couple of reasons. First, as everyone here I'm sure knows, financial institutions are highly regulated. There are many regulatory bodies at the federal level that have a hand in financial institutions. Those regulators have obviously given interpretations of statutes over time. And when helpful to them, class plaintiffs have used those interpretations to their advantage when bringing statutory claim on behalf of putative classes. So defendants should be thinking about whether Loper's decision can help them going forward. And we've already seen this approach in labor and TCPA cases where using Loper has helped in defending against class actions, and we should expect to see the same thing going forward in financial institution cases. A quick example of that, CFPB versus Townstone Financial. It shows kind of the limitations of those types of arguments. There, the court, the Seventh Circuit, analyzed whether the Equal Credit Opportunity Act, which Congress passed to ensure that lenders making credit available to people did so equally without discrimination. There was a regulation that the Federal Reserve initially put forth, and in that case, Townstone Financial argued that essentially it shouldn't be governed by the regulation. The Seventh Circuit, the District Court granted a motion to dismiss on that basis, and the Seventh Circuit reversed. In doing so, it explicitly noted that Loper, although overturning Chevron, it created or left open the opportunity for the regulator's interpretation of a statute to govern where Congress in the act gave the regulator discretion. And the court found that that was the case here. So there's going to be some limitations on using Loper going forward, but it's something that financial institution defendants need to keep in mind. The next topic is standing as a defense to class actions after TransUnion. So as most people know, just a quick reminder, TransUnion really clarified the court's rules on Article 3 standing. focused on the concreteness portion of standing. And there are a couple takeaways from that case that are important really for all defendants in federal court. The first is, even in the context of statutory violations, a plaintiff must have a concrete injury. The second is just what that means is there's a distinction between Congress's ability to create a statutory cause of action and a plaintiff suffering a concrete harm that will allow it to get into federal court because of an alleged violation of that statute. And so the court really highlighted that distinction. It also identified, or it also clarified that intangible harms can be concrete injuries, but they have to have a close relationship to a traditionally recognized harm. It also established that a risk of future harm alone is not enough for a damages class, which is important to all class defendants, and additionally said that every class member must have Article 3 standing to recover individual damages. So this is an important case really for all class defense, and we've seen it continue to be applied. Cassie, if you go to the next slide, in the context of financial institutions. So Arndt versus government enterprise, or I'm sorry, Geico, we'll just go with Geico, is a prime example of that. The plaintiff filed a putative class action against Geico, alleging that Geico violated a number of statutes for its use of session replay. Session replay is a technology that collects information from a user's interaction with a website. In effect, the software allows companies to view what a user's interaction with a website looks like in a visual recreation. Lots of companies use session replay to analyze how their users interact with websites. There were many lawsuits filed this year alleging that companies violated statutes through session replay. In this case, plaintiff alleged that Geico did so. The court ultimately dismissed for lack of standing, and it's important to recognize in these cases, the plaintiffs typically are not alleging any type of normally tangible, recognized concrete harm, like a monetary loss or an economic loss. And so the court in this case dismissed for lack of standing. In doing so, it analyzed the matter under TransUnion's framework and looked to whether intangible harms that were alleged bore a close relationship to traditionally recognized harms. And it found it didn't, because plaintiff did not allege that Geico captured sufficiently intimate or personal information for which the plaintiff would have a legitimate expectation of privacy. So this is a great example of using TransUnion when a plaintiff alleges a bare statutory violation, which frequently happens against financial services companies. Next slide, please, Cassie. So I previewed that this wasn't always the case, and that TransUnion cases or courts interpreting TransUnion have gone different ways. Particular negative case for the financial services defense bar is Torres versus Prudential Financial in the Northern District of California. That court essentially went the opposite direction of the Geico case that I just talked about. It found that California's Invasion of Privacy Act created a substantive right, the violation of which was enough to cause a concrete harm, giving rise to Article 3 standing. And the court found that, again, in a session replay case, a plaintiff had alleged sufficient facts to meet that Article 3 standard under TransUnion. In addition, the court did all of this while certifying a class. And so the court did a typical Rule 23 analysis after looking at that standing question. If we could go to the next slide, Cassie. So one final case that I want to talk about is career counseling versus AmeriFactors Financial Group. In that case, plaintiff alleged that AmeriFactors Financial Group sent unsolicited faxes in violation of the TCPA. The court, the Fourth Circuit, affirmed the District of South Carolina's denial of class certification for lack of ascertainability and really reiterated the ascertainability standard in the Fourth Circuit. So plaintiffs have filed a petition for writ, as I cited with the Supreme Court in that case, arguing that there's a circuit split regarding whether administrative feasibility is a prerequisite for class certification, and also on an interpretation of the TCPA. So I just want to watch out for to see if the court takes the case, and if it does, whether there are any changes to the ascertainability analysis. As a final wrap up here, next slide, please, Cassie. Just a couple of predictions. I'm going to move quickly because we're short on time. We're going to see more cases providing clarity on the impact of Cantero and Loper for financial institutions. We're also, I think, going to continue to see courts split on standing. Similar to the two cases I highlighted here, I don't think the Supreme Court is going to weigh in until after 2025. We're going to continue to see, and we already have seen early this month, additional cases getting filed related to fees that banks are offering. And then lastly, probably most importantly, we're gonna, I think, see some widespread changes in regulators' approaches as the new administration comes in, and those regulators' approaches will probably portend, as they usually do, how the plaintiffs' bar will look to sue financial institutions. And with that, I'm going to hand things over to Julie to talk about appellate decisions.
Thanks, Dante. We'll end this webinar with a recap of some of the critical appellate decisions that either directly impact class actions or could impact class actions. Because our mid-year update in September did not separately address appellate decisions, we didn't have a separate section on that. I'll touch on some of the decisions throughout 2024. You'll see up here on this slide, I have number 1, goodbye Chevron, and that is the decision that Dante just addressed, the Supreme Court's decision in Loper Bright Enterprises versus Raimondo in June, overruling the Chevron doctrine. There are also key decisions from the Supreme Court regarding arbitration, and then the Seventh Circuit's blow to mass arbitration, which was welcome to some of us who represent defendants in class actions. The appellate courts also continued to address standing and other jurisdictional challenges. And as we predicted in our predictions for 2024, there was continued scrutiny of class action settlements. Next slide. There were a number of decisions from the appellate courts, including the Supreme Court, regarding arbitrations in 2024. I'll touch on 2 from the Supreme Court, which show the pull between what the courts are to do and what the arbitrators are to do. Bethany touched on Coinbase in our September presentation, but it's worthy of re-mention. In May, in Coinbase versus Susky, the Supreme Court held that where there are 2 applicable contracts, one setting arbitrability disputes to arbitration and the other sending such disputes to the courts, it is the court that must decide which contract governs. And this is because arbitration is a matter of contract, and a court needs to decide what the parties have agreed to. And then in April, the Supreme Court addressed Smith versus Sparisi, and that is a case where there was a dispute as to whether the court was to stay a case pending arbitration or dismiss a case pending arbitration if one of the parties requested a stay. The district court in that case dismissed the action pending arbitration over the request of the plaintiff, saying that it had discretion to dismiss the case. While the Ninth Circuit affirmed that dismissal, it did note that the plain text of the FAA appears to mandate a stay, but that it was bound by Ninth Circuit precedent, which recognizes that the district courts have discretion. The Supreme Court ultimately held that use of the word shall creates a mandatory obligation that leaves no place for discretion, and that the court disagreed with plaintiff's theory that stay means only that the court must stop parallel in-court litigation, and so that a dismissal achieves that result as well. And then the court noted finally that staying rather than dismissing is consistent with Congress's intent to move the parties out of court, and a dismissal would trigger a right to an immediate appeal. And that the court also noted that staying rather than dismissing ensures that the parties can more easily return to federal court if the arbitration breaks down, and that also it comports with the supervisory role that the FAA envisioned for courts to maintain over the cases. Next slide. In a welcome decision to some of those, I had mentioned during the January presentation that the Seventh Circuit was set to consider the Northern District of Illinois' order compelling Samsung to arbitrate 35,000 individual claims and pay millions in filing fees. And the Supreme Court did take this up and in July reversed the lower court and concluded that when the FAA closed the claims, the parties had fully arbitrated in accordance with their agreement, which delegated the fee dispute to the AAA. And the court said that the court did not have the authority to require the defendant, Samsung here, to arbitrate and to pay the fees. And then after that, the Lukitsch decision, just 30 days later, the court summarily reversed another appeal pending before it, Haque versus Samsung Electronics America, which was fronted but on the same claims, which the court recognized as being successive to Lukitsch. That case was a little factually different because in that case, Samsung did not pay the fees by the deadline, asked for an extension, and then when that extension was approaching, both parties jointly requested that the AAA stay the arbitration to allow for mediation of the claims, and the AAA declined and it terminated the proceedings based on Samsung's refusal to pay the fees. And the court noted the distinction that there the consumers could refile the arbitration demands if the mediation failed. Yet when the mediation did in fact fail, the consumers filed a petition to compel arbitration instead of refiling in the arbitration. So the Seventh Circuit in just reversing held that either the case was on all fours with Lukitsch requiring reversal, or the district court orders compelling arbitration was premature since the consumers had to first refile the arbitrations, which it did not do. Next slide. Every single one of my colleagues has addressed standing because standing is and remains a critical issue that the court looks at in all types of class actions. And in Chavez versus Plan Benefit Services, Inc., the Fifth Circuit took a very deep dive as to the relationship between class representatives' claims and absent class members. And it recognized that there are two approaches that courts look at when they assess whether the named plaintiff's claims and injuries are the same as the rest of the class. There is the class certification approach, where a court looks only at whether a named plaintiff has standing to bring her own claims, and that it leaves any addressing of the quote with the court uses the word disjuncture between the plaintiffs and absent class members' injuries for the Rule 23 analysis and determination whether those elements are met. And this approach is followed in the First, Third, Sixth, and Ninth Circuits. Other circuits look at a standing approach, and they address whether the class representative lacks standing to pursue the class members' claims because they did not suffer the same injuries. And this is what's followed by several circuits, with the Second and 11th Circuit applying the most rigorous formulations as to what constitutes the same injuries. The Ninth Circuit sits on both sides of the fence, with taking both a class certification approach and a standing approach, and it interprets the requirements for a standing approach very loosely. The Fifth Circuit recognized that the Supreme Court has yet to declare which approach is correct. And interestingly, despite its deep dive into the different approaches, it declined to adopt either approach, basically finding that either under both approaches, there was standing and class certification was appropriate. And the petition for writ of cert was denied in this matter a couple of weeks ago. Next slide. The courts considered to address jurisdictional challenges, and in the end of this year, but the decision came out January of this year, so I'm sweeping it into the 2024 year in review. The Supreme Court considered whether of a post-removal amendment to a complaint that removes all federal questions, whether the case can remain in federal court. In that case, the plaintiff fought long and hard to keep their case out of federal court. They filed it in state court for deceptive marketing practices. The defendant removed on the basis that there were allegations regarding violations of the Federal Drug and Cosmetic Acts, and that even though there were not specific independent causes of action under that act, that there was still federal question jurisdiction. The Eighth Circuit agreed and did not remand it. The consumer then amended the complaint to no longer assert or mention the FDCA at all, and then when refused to remand it and then dismissed it on the merits, the Supreme Court found that post-removal amendment of a complaint to remove all federal questions deprived the district court of supplemental jurisdiction over remaining state law claims, basically finding that the plaintiff is master of the complaint and that plaintiffs often plead to avoid certain courts or to proceed on certain causes of action. And then just following up what Dante briefly touched on in addressing session replay cases, that has, in addition to causing the courts to address standing, courts are also addressing whether there is personal jurisdiction over the defendants simply by virtue of the defendants operating websites that are accessible in a forum state. The Third Circuit, it was two cases, one against Full Story and one against Papa John's, addressed whether just sending a website into a state, making it accessible, conveys personal jurisdiction, and the court found that it did not. That simply operating a website accessible in a state does not equate to targeting a specific estate, even if you can filter by store and you can search by nearby restaurants. Likewise, in a case against Bloomingdale's, the First Circuit found that the Massachusetts did not have personal jurisdiction over an out-of-state department store chain simply because users in that state could visit the website and because there were brick and mortar stores in that state. The Eighth Circuit just recently punted on that issue in two cases, one against Bloomingdale's and one again against Papa John's, where there was two cases, one dismissed for lack of standing, one dismissed for lack of personal jurisdiction. And the court, because it didn't find standing, said it didn't need to address either whether the courts have personal jurisdiction. Next slide. And then as we predicted about a year ago, courts continue to heavily scrutinize class action settlements. This includes making sure that there is a named plaintiff that corresponds to the claims against any named defendant. And you can't simply add defendants and not add a plaintiff that would have standing against that defendant separately. And then also the courts continue to heavily scrutinize attorneys' fees, and the Eighth Circuit reversed a $79 million fee award, which represented 22.5% of a $350 million settlement fund in a case against an MDL against T-Mobile regarding a data breach impacting 76 million Americans. The court refused to enter a per se rule that the percentage must be reduced in megafund cases, but determined that the fee must be reasonable, and in that case found that a lodestar of 9.6% was not reasonable. And finally, just some key predictions for 2025. Next slide. It'll be interesting to see that the impact of the Supreme Court's Loper-Bright decision over class actions. Dante touched on how this impacts the CFPB regulations and rules. We also anticipate it will impact, the SEC, EPA, and the FTC, especially with the number of consumer class actions regarding unfair competition, UDAP, antitrust, and privacy and consumer protection claims. We expect more appellate activity regarding arbitration, as well as the courts to continue to address jurisdiction and standing, even if the parties don't raise it, and to continue heavily scrutinizing class action settlements. And with that, and sorry for the whirlwind there at the end, I will turn it back over to Bethany to close out our program.
So thank you for attending today. We really appreciate your attendance. Our last CLE code is snake, as it is the year of the snake. Please jot this down for your post-webinar survey. And if you liked today's webinar, we have a couple of more webinars coming up. If you have any questions, please feel free to reach out to any of us. We would be happy to answer your questions. This concludes the program. And for those of you who would like CLE credit, please stick around for the post-webinar survey where you'll be asked for your bar number and the CLE codes given during this presentation. Thanks so much for joining us.